Good morning, Namaskar, Sat Sri Akal and Adab. This is my 280th video, and this video will be covering the definitions of grant. Let's refer the very first definition, which is Land System of British India by B.H.BADEN-POWELL. The definition of grant during the period in Punjab which he mentioned was that grants were in actually revenue assignments. The revenue to be paid by the grantee to its ruler or government. Now, in this case of our grant, we were whether paying any revenue. Grants given by the rulers were revenue free. The owner was exempted from Lagan to be paid by him. British government seized all such revenue free assignments called old grants, converted all such old grants into new grants. Proper documentation and deeds were written. It refers to a Financial Commissioner Circular number 37 under the Land Revenue Act. Now, this is written on page 602 of the book. So, we need to just lay our hands on these books. Another book which came across me was the Wells Report of Lindore Cantonment or Doon Valley. On page 8, the difference affected the amount of revenue and the date of the revision of assessment. It did not affect the invariable and therefore implied reservation by government to its of the spontaneous products of the soil such as streams and minerals, a reservation mentioned in most village vasibulars. I have so far been unable to obtain a copy of the grant conditions of the period of 1838 and 1840. But I have come across some papers in a miscellaneous file of English in 1842. And this is what the file says. The extract of a letter from Revenue Survey Superintendent Dehradun, 21st February 1830. On the occasion of submitting a plan to the grant called Arcadia as a specimen on the way the lands were returned. Now, this extract, although unsigned, appears to me, but is in the handwriting of Captain W. Brown, who was made the survey as well as the settlement officer in this report of the Wells settlement. Now, para 4 and 5, what does it speak? I now proceed to notice the point mentioned in the correspondence regarding the grants on which it is expected I should afford information. Para 5, the grantor should be called upon to make the required roads through the grant, and government reserves the right of stream of waters in case it should be found desirable for establishment of a distribution system. That is, of water, which is canals, roads have to be made. So, these were the kind of conditions which were given in the grants given in 1838 and 1840. But we are a grant of 1836. In the grant again of 1845, the rights of government to all mineral products and the rights of distribution or water for irrigation is expressively mentioned in condition 13 and 14. Now we need to read Rose Settlement Report of 1852. And this is a very important report. Similarly, precise conditions were embodied in the grants of subsequent year. Now the Wells settlement of Missouri, although it dealt with non-agriculture lands, was from the very first conduct as if it were an ordinary revenue settlement. This is clear from the use of the word settlement and other revenue terms. All orders and directions were given through the Board of Revenue. In absence, therefore, of evidence on the contrary, it must be resumed that the terms grants was used in its established revenue connotation. So this is very important. It meant the lease of full rights over the lands in question, subject always to the reservation by government of its inherent rights to use the streams and appropriate minerals. I therefore hold that the use of the word grant ipso facto avoided the necessity of any condition in the body of the grant. So, a grant by itself meant this. So, grant was a freehold grant all along, which I have been always saying. I would observe that the embodiment of such conditions in later grants in the Doon cannot legitimately be used as an argument to prove on the principles of exception probate legema that no such reservation was intended in Wells Settlements grant. For this was due to nothing more than the greater perfection in accuracy and completeness of the document. More formal periods during the Indian administration. So, what is Wells' report trying to say? Again, it is defining grant. Let us suppose, however, that the mere use of the term grant was not sufficient to imply this reservation. It can nevertheless be shown that the reservation was one of the implied terms of the contract between the government and the grantee. Now, for government in Wells settlement merely confirmed and took over, as it were, the transfers of the zamindars which had already taken place in favor of the grantees. So, these are the kind of definitions which have been used, and we need to understand these definitions. Everywhere in every province, there were 5 provinces, the definition changes, and we need to understand this definition. Now, the same definition is defined in Imperial Gazetteer of India 1909. Deduction by way of assignment of revenue. Once again in 1909, 1836 to 1909. Land revenue receipts are peculiar oriental in its origin, namely that due to the practice of assigning or alienation to individuals the rights of government to collect its demand from the land, or of permitting individuals to hold their land wholly or partially revenue free. Is that clear? That is why I say we are old grants, we are revenue free grants. Now I am talking about Ambala province was taken over from the preceding native ruler. An immense number of such grants were found in existence. And an immense time was spent in the early days of the British rule in determining to what extent and what terms such grants should be continued. New grants on this chapter is still sometimes made, but the majority of those now in existence are an inheritance from native rule. So clearly it is saying that in Ambala all grants were old grants, they were from the natives, and the natives, the rule was transferred to the British. They owe many causes, but mostly service of any kind to government or community. And although the service is often of an intangible nature or now has become ancient history, the maintenance of these grants were recognized as fair charge on the state. Imperial Gazetteer, page number 227. Now, friends, we will read another act of 1869, Act number 1, passed by the Governor General of India in Council for Awadh State. Grantee means any person upon whom the proprietary rights in the state has been conferred by a special grant of British government and whose name is entered in the 5th and 6th of the list definition of a state. Now, This is where we have to fight it out. In a statutory, when you do not have a definition on one statutory, you can always make use of another statutory. Now, we've been called estates. Now, what does estate means? The taluk, or an immovable property acquired by a talukdar or a grantee, which we are, in the manner mentioned in section 4 and 5 of the immovable property, conferred by a special grant of the British government upon the grantee. So we can always lead this evidence and get this GGO of 1869 our. But why is it that the Director General Lands must tender the definition of grant, and within the same, exceptionally the old grant, rebring any act or rule where the same is defined for the military purpose? They will never bring it because they don't have one. We, after independence, and the system is basically harping on the system which was by the British itself. Nothing changed for the cantonments on 15th August 1947. We are yet subjective to the Governor General orders. Regulations are applied on us. Acts do not take place on us. And talking of the Constitution of India, please friends, I have already briefed. 1935 Government of India Act, or the Constitution said by them, is a replica to the Constitution of India 1950. Why? Because one thing is clear, both people sitting post and pre 1947 knew that we are old grants and we were never converted into new grants by the British as per these definitions. So we were revenue free grants and we are freehold properties. I hope you understand. You have any question, please get back to me. Thank you. Good day.